The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everybody. This is Noel here from Contact Distribution. Welcome to our webinar this morning. Thank you very much indeed for joining us. I just want to ask, before we kick off, just a small favor, make sure we have no gremlins. If everybody can hear me on your side, if you could just pop a message into the chat bar just to say that you can hear and that you have audio on your side, that would be really appreciated. Anybody can just pop a message in there to let us know you can hear us. That would be great. Okay, thank you, Gary. Appreciate that. Okay, we have some audio anyway. If any of our attendees can just pop a little message in there, just to let us know you can hear us. That would be really good. Okay, bear with us there, guys. We're just getting the audio finalized here. Okay, guys, just if anybody could just pop in a very quick message there, just let us know that you have audio on your side. It would be really great. Okay. Okay. Great. Okay, lovely, guys. We seem to have audio, so that's very much appreciated. Thank you very much. Okay, guys, so we're just 3 minutes in here, so we're going to kick off. We have the majority of the registrations are actually are with us now, so thank you very much indeed for joining us today, guys. So as you know, the nature of the webinar that we're hosting today is around GDPR, getting the principles right, and we're very proud to have Gary Hibberd on the line with us here, who's going to go through some of the details with us. So really, what the nature of today's webinar is, as we say, it's an overview of the principles, and it's really so that at the end of the webinar here, what we can do is we can all walk away with some of the key actions that we need to take, that we need to address in order to find ourselves in a good place for GDPR. Obviously, GDPR is it's very much the big thing at the moment. Well, with the May deadline coming very fast down the line, and we're kind of conscious that a lot of people haven't actually begun to start a journey onto GDPR compliance just as of yet. So at the end of this session, we will all have some key actions that we're going to take to bring us into a very good place. So before we kick off, just to remind once again that the presentation and the webinar today is brought to us by StorageCraft. So I know among the recipients and on the webinar today, we have both new and existing partners of StorageCraft. And of course, we have some partners online here who haven't actually discovered StorageCraft as of yet. So just a very quick overview on the company overview of StorageCraft itself. So for those of you who don't know, StorageCraft founded in 2003 with the head offices there in Utah, and with offices also in California, Asia, and Pacific. Very important, we want to point out here that the EMEA HQ for StorageCraft is actually based in Cork City. So a very good thing for us based here in Ireland. It does mean that should anybody need to get technical overview, should anybody need to talk to a specialist, be that sales, commercial, or technical, you're always welcome to drop into the office down in Cork. The other thing to remember very importantly here is that StorageCraft is a channel-focused company. So for all of us on the line here who have familiarity with distribution through the different vendors, we do want to point out that it is a channel-focused company and it's a channel-only company. So we're working with, as you can see, a huge number of value-added resellers and a huge number of MSPs as well. Among the range, we know that StorageCraft is a key vendor in the world of backup and replication, but not only that, it's also a key vendor in the world of business continuity. So I think it's fair to say that the days of just backup and recovery are gone now. It's really all about business continuity, and that's exactly what StorageCraft brings to us. both through the traditional perpetual model, and also through a very advanced MSP model as well, where we have options for all the licensing in MSP and all of the options that we could possibly ever need for cloud backup, including the ability to spin machines up in the cloud in the event of disaster. Anybody who doesn't know about that but would like to know more, please get in contact with me directly. We can see there's some recent acquisitions, and the one that I'd really like to draw your attention to is the one of Exablocks there, acquired in January 2017. This is a very interesting object-based storage solution, and we will send some follow-up information to everybody who's on the line here with us today to tell you a little bit more about that as well. Rapid growth and expansion. We can see that here in Ireland among our own partners, both our VARs and our MSPs. We see huge expansion, and we hope a lot of you on the line here today will be able to join us with that expansion and find exactly how StorageCraft is able to complement your MSP business. So thank you for that, and without any further ado, I am going to pass you across to Gary, who's going to go through the main reason we're all on here today. So thank you all very much, and I will speak to you at the end of the webinar. Over to you, Gary.
Thank you very much. Good morning, everybody. I hope you're well. I'm just going to bring up my slideshow now, so hopefully you can you'll be able to see this. You should be seeing before you now the agency logo, and Noel, I presume you can see that. So if we can't, feel free to stop me. So this presentation today is about GDPR. It's a topic that I think is the hot topic certainly for 2017, and is set to continue within 2018. Agency, who are agency? Who am I? Well, I'm not going to go into too much detail because I was just invited to talk about GDPR, so that's going to be my main focus. You will be able to see my web address at the bottom and my email address if you want to take my contact details should you feel the need to contact me after this. There will be a Q&A session at the end. But the agency, what you need to know is that we're not a legal practice. We are a cybersecurity, information security business. I've been involved in data protection and information security and IT for well over 30 years. And we've seen a lot of changes, both in technology and thankfully in the way that we are using data and how we're protecting it. So the thrust of this presentation really is all about GDPR, this wonderful new regulation, the General Data Protection Regulation. We're going to go through the principles. What is it really about? But by the end of this, I'm also going to give you some tips and some tricks that will hopefully get you on the path of being able to evidence compliance to this new regulation. So, first of all, our agenda. What is the GDPR? We're going to go into the principles. The devil, of course, is always in the detail, and principally what we need to do. As I said, my contact details at the bottom there, and the web address, should you need it, is www.theagency.com. So, what is the GDPR? Well, that's where we should really start with this. It's a significant change in data protection regulations. Within the agency, we've kind of coined a phrase, and we've been doing this, we've been talking about this for well over 2 or 3 years now. In terms of what GDPR is, we believe it's simply about giving data proper respect. It's about looking at data as if it's your data, rather than just looking at it as something that somebody has sold to you. We are asking organizations and individuals to think about the data is, if this was your data, how would you expect it to be used? How would you expect it to be treated? And if you can start to have that almost emotional shift with GDPR, it really does help. And I do often say in conferences and seminars is when people say to me, is GDPR relevant to me? I will always say, it's relevant to you, it's relevant to your children, it's relevant to your families, it's your parents, it talks to you at a personal level. So if you're struggling to understand or get engagement with GDPR in your organization, almost my first tip is to make this quite personal, because it will absolutely affect you. But of course, talking about this on a business level, well, who does it really affect? Well, of course, we know it's an EU regulation. It's much needed. You know, the countries came together back in 2012 and said the data protection laws are inadequate. They are hampering business across the EU. So we need to have a uniformed approach to how we protect data, how we share data, how we process that data. So the EU countries came together and said we need to have a uniformed approach to this. Essentially, what GDPR is about the protection of processing activities for organisations and legal entities that are operating within the EU. So if you are within the European Union, this absolutely affects you. And it also, and this comes as a surprise to some, if you operate outside of the EU, but you sell goods and services to individuals within the EU, so if your customers are based within the EU, this absolutely affects you as well. That often comes as a surprise when I'm talking to organizations who are based in America or Canada or and even further afield. At this point, I would just like to mention Brexit. Again, this is another area which many people say, well, what's going to happen after Brexit? Just so you're aware that alongside GDPR within the UK, sorry, there is the data protection bill that is going to be enacted, and all that does is it enshrines GDPR into UK law. So Brexit won't affect it, and that's a direct quote from Elizabeth Denham, the Information Commissioner. And she's had a lot to say about GDPR because there is a lot to say about it. She's actually said herself, there's a lot that in GDPR you'll recognise from the current law, but it is a game changer. And it needs to be a game changer because, as she states here, that 3/4 of us don't trust businesses to do the right things with our information. And she finds that shocking. I find that shocking, but sadly not surprising. If you are looking for GDPR to be a negative thing, you can absolutely find that, and we'll touch on that shortly. But I think, as Elizabeth Denham stated here, you know, having being able to build trust with your customers is a cornerstone to any good business. And having good compliance, or demonstrating that you are doing the right things and treating data with respect, that's got to be a good thing. I would like to work with organizations and for organizations that are treating people's data with respect. So that's a good way, it's a good positive thing that GDPR is bringing to us. Of course, you know, with GDPR being the headline news over the last 12 months and further past, you'll have heard the main headlines. And some of these headlines will come as no surprise to you, but it's worth having them on screen right before you now. You know, I'm not going to go through bulleted pages here. Just this is really so that you can see this and you can refer to this once this presentation is over. But as you can see here, a key date for you to put into your diaries is the 25th of May, 2018. But I would just simply say to you is, whilst it is important date and we should be working towards it, we should just recognize that this is about changing our approach to how we use data and how we protect and process data. So whilst, yes, that date is important to us because on the 25th of May, it gives the Information Commissioner's Office new powers to enforce certain restrictions, certain rules upon us. But in actual fact, we've actually been operating under GDPR since the 14th of April 2016. It's just that it will be enforceable from the 25th of May. But if you haven't started, don't panic. And that again is almost a central theme to this presentation is there are things you can do and there are things you should be doing, but there shouldn't be a panic about this. This is just about doing the right things. So these are the headlines that undoubtedly you'll have seen at some point. One of the biggest areas that, of course, that we get the headlines and it gets the attention of social media and it gets the attention of lots of consultants who are selling on fear and uncertainty and doubt is, of course, the fines. And yes, I am going to talk about the fines because that would be remiss of me not to. If you get it wrong under the GDPR, it gives you very clear ramifications for what will happen. And if you get it wrong, if there is an offence such as you don't seek consent correctly, or if you're not treating data with transparency, you could be looking at or liable to a fine of 2% of your annual turnover. That's not profit, but turnover. And that's global, if you're a global organisation, or up to 10 million euros. That's one of the minor fines. In actual fact, it can go as high as 4% of your annual turnover, or up to 20 million euros. This is the scary piece. This is the bit that people, consultants, dare I say it, like me, will often lead on and try and sell their services on the back of it. I prefer to say that there is an opportunity here. There is benefits to this. It is unlikely that the ICO will levy out these large fines, but we don't know. And all I would say is this is enshrined in law. It's within the GDPR, it's Article 83, and these are large fines. 4% of your annual turnover, or up to 20 million euros, whichever is the highest, whichever is the greater. So we need to consider that. But, and this is the important big but I'd like to highlight, and that is that there are considerations, again, within that same article, which many consultants forget to mention, is it does state that those fines will only be based upon the nature and gravity of the infringement, the actions taken by you to mitigate the damage suffered to the data subjects, and also the intentional neglect, the neglectful character of that infringement. So essentially, in layman's terms, it means this: you are unlikely to have a fine if you can demonstrate that you have done your best, you've done your level best to protect the data that is under your control. It will be unlikely to be a heavy fine if you can demonstrate that once that fine, data breach occurred, that you did all you could to protect the data subject. So you didn't hide, you didn't simply mask the fact that you'd had a data breach. Essentially, you treat the data and the data subjects with respect, because it is about protecting people's personal data. And again, we need to remember that is what GDPR is all about. It's about protecting individuals, data subjects, and the personal data. What is personal data? Well, personal data means simply this, and this is the actual quote from the regulation itself. It's Article 4.1. So right from the beginning of the GDPR, it states what they're looking to protect, what is identifiable as personal data. And it is very far-reaching, as you can clearly see there. The rest of these slides, by the way, will absolutely have lots of words on them, but I'm not going to go through it ad infinitum, because that would be boring for you. And again, it's really there for you for reference at a later point. So what is processing? Processing, well, again, it's far-reaching, and we just need to understand that it means literally, you know, that anything that you do with data. So it is the collection, recording, organization, structured storage, adaptation, or alteration of data. So it's pretty much anything you can do with data is what it's referring to. How big is GDPR? Well, there you are. If you're interested in reading GDPR, and I'm hoping some of you will be after this if you haven't already read it, it's 261 pages, so it's not a long read, it's not a big book. It's made up in a number of chapters here, but if you are interested in a cheat sheet, if you like, almost you know, what is, if I only need to read a small part of this, Gary, I don't want to read 261 pages, what do I need to read? I would ask you to focus on chapter 2, the principles, articles 5 to 11, because that will give you deeper insight into what you are meant to do. I'm not a lawyer, as I said at the beginning. Yes, I've been involved in technology and cyber security for many years and data protection, but I have to be honest with you and say that GDPR is not a tough read, even for a layperson. So it's not something that is impenetrable. And again, I would say, if you are wondering how to read it, I think I've read it now into double digits. So I've read it at least 10 or 11 times. And the way that I've got through that is by putting myself at the center of GDPR. This document is talking about me. So what is it talking about? Well, the core principles to GDPR is under Article 5, and it's talking about these 6 principles. And essentially what it's saying is that personal data shall be treated lawfully and fair and with transparency, that there will be a limitation on the reasons why you can use that data, how much data can be collected, data minimization, that it will be accurate, that it will be stored only for a period as long as it is absolutely necessary, and of course it will be held in a secure fashion. And that's really what GDPR is all about. And again, repeating the words that I've said earlier, for me, that is about giving data proper respect. And when organizations say to me, well, does GDPR really matter to me? Do I have to apply it to my business? I'm clear of one thing, is that they've never read Article 5. And because I know that, because I would look at them and say, well, are you telling me you don't think it's right that you treat data with respect, that you don't collect excessive amounts of data, and that you don't hold it in a lawful manner, and you're not fair and you're not transparent about what you're doing with that data? Is that how you operate? Because if it is, I don't want to do business with you. So I don't think that is a bad principle to have. Now, there are the 6 principles as defined by GDPR. There is what's known commonly as the 7th principle, and that's the principle of accountability. That just simply means that you have to evidence that you're doing these things. Someone within your organization has to be accountable, and that doesn't mean, you know, you point at the CEO or the MD. Of course, they are ultimately accountable for everything, but what we're saying here is that you have to be able to evidence that you're doing the right things. So a slight change in language almost when we talk about being GDPR compliant with a capital T at the end. This is about you being able to evidence that you are treating data lawfully, and you are doing so in a fair way, and you are being transparent about it, and so on and so on. So the 7th principle is the principle of accountability. But we are going to now delve into these each of these areas here in a little bit more detail. Again, the slides will be quite wordy, but I'm not going to go through them line by line. You'll be pleased to hear. But our first principle, the lawful, fair, and transparency, essentially is just saying this, that data will be processed lawfully and fair and in a transparent manner in relation to the data subject. So you've got to think about how you are treating that information that you hold for the data subjects, and data subjects are essentially people, us, you, me, our children, our families, our parents, anybody that you do business with. And it will be only lawful if you can identify the reasons why you are, or have a legitimate legal reason for processing their data, for instance. And we'll come on to fair and transparency a little bit later, and we'll keep coming back to this. But this is a really important one to note here, because quite often, and we're going to talk about this in a second, about consent, which is, again, a topic that most people start fixating on when they're talking about GDPR. We have to remember that there are other reasons why you can process data. And I've heard so many times how organizations, again, unfortunately, consultants wrongly stating that you have to have consent for all the data that you hold. That's hogwash. You do not have to have consent for that. You have to have consent for information that you cannot, you are not, for instance, operating under contractual obligations. So if I go to a law firm and I say, I would like you to handle my my conveyancing or my divorce or my will, they don't then have to have my consent to hold that data, because in order for them to do the work, a contractual obligation, then they have to have my data. They don't need to seek my consent. So I'm going to come on to the consent in a little bit more detail, but just to be, again, a little bit more relaxed about this. I don't want you running scared of this idea of I've got to seek consent for everything I hold, because you don't. But of course, you need to ask yourself, what does transparency mean to you? How are you being able to demonstrate you're transparent? Are you telling people what you're doing with with the data that they're giving to you? So we come on to this a little bit later, talk about privacy notices. So how are you informing people what you're doing? Is that processing fair? And of course, is it lawful? And this idea of consent, if you are going to operate under consent, that simply means that you need to be able to demonstrate that you have obtained someone's consent. That will be typically for marketing purposes. So the solicitor, the law firm that I spoke of may say, well, we'd also like to take your data and we would like to share it with other departments. May we have your consent to do so? And I may say, no, I don't want you to do that. I only want you to hold my information and use it for the purposes for which I have given it to you. But if you need my consent to then market to me, then they can do so. It has to be, as again, all of these lines on here are all there for you to be able to take away and think about and how you can evidence that. The important one is, of course, pre-ticked boxes on websites. They have to be removed. So it has to be an affirmative action that I actually take. And for all of you out there who are marketeers and in the marketing departments with your heads in the hands saying, well, what are we going to do about all the data that we're holding on our customer relation management systems? There is a glimmer of hope. And that glimmer of hope is enshrined again within GDPR, because it actually states within Recycle 47, which recitals within these documents tend to be examples. So you have your articles and then you have recitals, which give you some context around some of the rules. And you'll see here, don't worry about reading all of this, because it's really this final part of this that you just need to be aware of. The processing of personal data for direct marketing purposes may be regarded as carried out for legitimate interests. It may be fine, because again, if I go to the law firm and say, I would like you to handle my conveyancing, they may be able to send information to me about financial services parts of their department that can help me save money as part of that conveyancing, or to give me additional services, but are very linked to what I originally gave them permission to use my data for. So there may be a legitimate reason that you would want to be able to market to me. But again, a key word in there is may be regarded. So it may be. You have to make that assessment yourselves. And that's the key point. So that's all I'm going to say about that particular principle. So that's the first principle. The second is about purpose limitation. And again, this is very, very, very simple. It makes perfect sense that you can only collect data for specified reasons, and it has to be legitimate purposes and not processed in a different way. And that's really important. So what it means to you is, how can you be sure you're collecting the data for legitimate reasons and only for those reasons? You're not going to take that information into your business and then start to sell it on. And again, you can imagine some organizations, and I'm thinking more about the social media companies who run dating websites or employment websites, who are gathering large swathes of information, personal information, and then selling that to insurers or selling that to third parties, so that you suddenly start getting spam email about pharmaceuticals or health products or whatever it might be. Is it right that your gymnasium, that you went and you gave them all your credentials about your drinking habits and about your health, suddenly take that information and sell it to a local bar or a local restaurant to say, we reckon, we understand that you enjoy eating this thing or whatever it might be. So it's about, are you collecting information for only a specific reason? So you can only use it for the purposes that you have set out, and that you have informed me as the data subject of what you're using that for. Data minimization, again, is it adequate? Is it relevant? If you go into a hotel, is it right that they give you, they ask you some questions? Of course they do. They ask your name and they ask you maybe your car registration, because it may be parked in their car park. But if they start asking you about your sexuality or about your sleeping habits and about your drinking habits, well, that would be seen to be excessive. So it should be limited to what you are needing to process that data for. But a key question for you is, do you know what information you hold? And are you collecting just enough to be able to process it? So again, looking at your own processes, what are you doing about that? Accuracy, well, this is, I think, fairly obvious, is that data should be kept accurate. And again, we can all think of circumstances and situations where our data hasn't been held in an accurate manner. So GDPR is just saying to you as an organization, as a central principle, you will keep data accurate, and it will be every reasonable step you will take to make sure that any inaccuracies are corrected as soon as possible. That doesn't seem onerous to me. It doesn't seem a problem. Of course, you've got to think about how your data is being stored. So, you know, is it updated regularly? Do you have an audit process in place? If you don't, then you need to think about how do you do that? Do you take a sample and check that the information is accurate? Do you have a process where individuals who have a problem may be able to come to you and say, that data is inaccurate, or I want to have access to all of my data, please? In that case, you need to have a subject access request process. You need to think about other processes that you need to incorporate into your business to make sure that the data is correct. The penultimate principle is one about storage limitation. And this is, whilst it's a fairly long principle, it does talk about here just about holding data for only as long as it is necessary. And again, this is a key word, how long it is necessary for the purposes for which the personal data are processed. I've had organizations run in a panic saying, Gary, but we have to hold this information for 7 years or for 10 years or for 50 years or for 100 years. And my response is, don't panic, that's fine. If you can demonstrate you have a lawful basis to hold that information, don't worry, that's a good thing. All we need you to do is evidence that you've thought about it. So just simply document a data retention policy. Have something in place that allows you to demonstrate that you've thought about this. So you will speak to people in your organization, you'll speak to HR, you'll speak to finance, you'll speak to your operations. What personal data do we hold? How long do we have to hold it for? And that's all that this really storage limitation is there to try and enact. The final principle that you need to be aware of and to try and to get to grips with is, of course, the area where I initially came into data protection so many years ago, was around confidentiality and integrity, the security of the data. So again, it talks about here that the data will be processed in a manner that ensures appropriate security of the personal data. And again, I'm going to draw your attention to a key word, appropriate. What is appropriate to you as a small company, 5 people in an office, 50 people in a building, 1,000 people across the globe, is going to be completely different. Is it appropriate that an organization like Facebook uses free antivirus software? Well, probably not. They should have a fully fledged security team, whereas a small 2-man band might be, you know, a sole trader might say, well, I've got antivirus software on my machine, it's free version because I'm a sole trader. Is that appropriate? Well, absolutely. You've taken some appropriate technical steps. And it's about making sure that you have done that. But it's also looking again, the key word, appropriate technical or organizational measures. Don't just think you can throw an IT solution at GDPR and think the problem will go away. And I'm sorry to say, you know, if there's anyone who's an IT provider out there that is selling on the back of this, you know, that's a good thing. That there are tools that you will need. There are things that you should have, absolutely. But GDPR is not an IT issue. It's a business risk, and you need to remember that. So we need to think about what organizational measures. So do you do training and awareness? Do you actually sit down with people and explain to them their roles and responsibilities around security? Now, of course, you can do things such as implement security standards like ISO 27001 or Cyber Essentials, these security standards, and they are far-reaching. There's a lot to them, and they are very beneficial, and that's what agency does. We've been doing this for a good number of years, helping organizations build these security frameworks that do all these things that, as you can see here highlighted, offer you all of this ability to evidence that you are doing the right things, and thereby demonstrating accountability. You are saying we are accountable for the data we hold, and we understand that, and we are taking responsible actions to treat data with respect. And that's all that Elizabeth Denham and the ICO are looking for you to do, and that accountability is of key importance. But it's not just on the 25th of May. Elizabeth Denham herself has said that accountability is at the center of it all, and it's getting it right in May, getting it right beyond that as well. So it's not just about thinking about those days, those dates, sorry. In terms of what are, any key areas, anything else that you need to be aware of? Well, absolutely. And just very quickly, I'm just going to talk about data subject rights. Under GDPR, there are new rights that organizations have to give to data subjects. So you as an individual have right to access the information. You have a right to have that information removed or erased, or to be forgotten. The right to be forgotten is another way that is explained. These are all the articles. It's Article 20, it's Article 21, it's Article 22, if you're interested in reading those in a little bit more detail. And it's important for you to be aware of what these are, because in terms of offering those rights, at the end of the day, giving people the right, for instance, to have access to their personal information is of key importance. Information to be provided where people where personal data is collected, for instance. When I talked about this earlier, at the time of you collecting data, you should be telling me what data you're holding, how you're going to treat it, who you're going to share it with. This typically sits on people's websites. This is the privacy notice that we often hear about. And organizations, large and small, are going to have to get better at doing this. And when I say large, I mean people like Apple, people like Facebook, LinkedIn, every other social media site that you can care to mention are going to have to get better at doing this. So again, I keep repeating myself when people say, will GDPR affect me? Well, if you're on any of those platforms or use any of those technologies, you're going to start to see some of these things coming down the way. So that's the part of the presentation which is very much about giving you an introduction to some key aspects of GDPR. So, well, what can you do and what should you be doing? Well, this is just a very, very quick, again, couple of slides here that I would just like to go through with you just very briefly. But again, they're here for you to reference at a later point. I always say this, when people say, well, where do I start? You cannot protect what you do not understand. So first point, do you understand your data landscape? Go out to your business, or rather get your business to come to you on a piece of paper, draw yourself in the middle, and then draw each of your departments around that circle, and then ask them what data in those areas. So HR, what personal data do you hold? Finance, what personal data do you hold? Operations, marketing, all of those areas that you can think of in your department, in your business, you should be asking them what information. And that allows you to create what's called an information asset register. You could do that through structured questionnaires, you can do it through interviews, you can do it through a workshop. However you do it, all you need to do is ask your business a few questions. What? Why are we holding it? Where is it? How is it being held? And who has access to it? It is really genuinely as simple as that. Once you understand your data landscape and you've got a good picture of it, well, it's time to have a bit of a spring clean. Because if you don't need it, why have you still got it? I dealt with a recruitment agency last year, and they've been in operation for a good 25 years. And in their words, we have, and quote unquote, we have between 10,000 and 45,000 records. They didn't understand their data landscape at all. That's too big a number. When they finally got down to it, it was around 30,000. And when we did some further data analysis, we actually identified that probably, I would say it was around about 40% of that data, if my memory serves me, that we could remove. They didn't need it. It was taking up valuable space, and it allowed them to focus on those people that they would be able to place. So again, a good business benefit. A spring clean helps everyone. So once you've done that, you can then have a data retention policy and ask yourselves that very simple question: why are we keeping it if we don't need it? The next thing, when you've understood what the data is, understanding how it's protected. So is it in a CRM? Is it in a database? Is it in spreadsheets? Is it where does it sit? And what are you actually doing with it? How is it? Is it being held in an encrypted format, etc.? So you need to think about how that is being protected. What are those organization and technical controls that you've put in place to ensure confidentiality and integrity? Those appropriate controls. And once you've done that, you really just simply need to build a plan on what to do when things go wrong. Unfortunately, data breaches are a far too common occurrence, and when people talk about a data breach, of course, a data breach can be as simple as you emailing your customers the wrong information or the personal details to the wrong email address. That is a data breach, because a data breach is classed as something that will have an impact upon a data subject's rights and freedoms. And their rights and freedoms means that you have to ask yourself, if this data was released to the wrong people, could this cause them distress or financial loss or have some negative impact upon their lives? A law firm a few years ago told me a story about how they had sent the medical records to the wrong house address simply because the data wasn't accurate. They got the wrong house address when they were taking the information, and a neighbour got to see highly sensitive, highly personal medical records of an individual, and it caused them eventually to have to move house because of what happened next. That absolutely was one person causing massive amounts of distress through one single email. So just understand what you need to do, how you would actually report an incident. So have you got a plan? If you don't, you just need to think about how you would do that. You can, of course, consider standards and security controls, you know, looking at things like the ISO 27001, but that might be too onerous. There might be other things that you want to do. There are other methods to be able to evidence that you are doing the right things, but it is just down to you. But as I think most of us recognize, you know, GDPR is not far away. It is closer than you think. Many organizations haven't started. It's not a bad thing. It's not a great place to be. Of course, it means you've got work to do. But I would still urge you not to panic. GDPR is not going to start and end on the 25th of May 2018. It's already in place. It was in place 2016, and organizations we were working with in 2016 were panicking about the upcoming date. Organizations we were working with last year were panicking about the 25th of May. And we kept assuring them and saying, look, guys, this is about a lifestyle change. This is about looking at data differently. No, you don't have very long to go. If you cut out the weekends, it is literally 95 days to get to the 25th of May. Of course, you've got more days, about 135 days if you're willing to work weekends, but you've got 95 days. But I would just simply urge you to treat GDPR almost like a diet plan. This is a new way of working. This is a new way of thinking about data. If you think as data is to your business as food is to you, if you're going onto a diet, every dietitian and every personal trainer in the world will say to you, you need to think differently about what you're consuming, how you're consuming it, and what you're doing with it. We are suffering in this world with information obesity, and I think it's a good time for us to go on a diet and to start to learn how to be better with our data, and ultimately to give data proper respect. So I hope that's been of interest. That is my presentation to you. I'm going to attempt now to hand back to Noel. So thank you very much for your attention. And as I said, I will just try and hand this back now to Noel.
Actually, Gary, if you pass it to me so that I can cover the questions.
No problem at all.
Okay.
Thank you.
Okay, so hi Gary and hi everybody. So there are some questions coming in, and I'd advise you, if any of you have got some questions that are thinking to ask them, get them in now, because so we want to make sure that we get to all of them. Okay, so first of all, Not a question, but a thank you, Gary, for clarifying so clearly an area that is being hyped up by so many. And I think, you know, a lot of us would also agree with that sentiment. There's a lot of people asking, will the slides be made available? And the answer is yes, we will be sharing the slides, and we'll also be sharing a recording of the webinar. So, so that's good. Okay, right. Next, first question, so Gary, is a question around a data protection officer, which you didn't mention, is how do you know if you need a data protection officer for your company?
Okay, it's a very good question. So under it's Article 37 of GDPR, it actually gives 3 reasons. You only need to designate a data protection officer if the processing is going to be carried out by a public authority, if your core activities of the of you, the controller or the processor are processing operations which are, you know, require regular systematic monitoring, and you know they're quite extensive and quite large. So that's the second reason. Or if the core activities of you, the controller or the processor, are on large quantities of special categories of data. So that would be children's data, medical records, that type of thing. So it is a real good question, and I probably should have included that. So thank you for asking. It's the data protection officer is a good question. Every organization should ask itself, do you think you need a data protection officer? If you don't, you should document that fact. But you should identify somebody who will be a data protection lead. So who's going to lead this? But if you are going to have a DPO, they will have very definite roles and responsibilities. And you can outsource your data protection officer as well. So you can have a virtual data protection officer. An agency have been offering virtual security officers for the last sort of 8-9 years. And now, you know, the GDPR is saying, look, if you're a small organization, but you feel that you are doing these things and you need somebody to keep on top of your data protection rules, then it's you can club together almost, and a number of organizations, so you know, a number of insurers, for instance, could all have a single data protection officer to help them. But absolutely, you do need a data protection lead, so someone who's going to lead this project.
Okay, and some more kind of corollary questions around that, specifically around sort of if you're a small sort of a GP or a dental practice, you know, so while you're a small company, you're dealing with very sensitive data, and in that case, do you need a data protection officer? What do you think?
Okay, I mean, in that respect, I mean, it's difficult to say because it's not to do with the size of your organization. That's something just to point out. It's more about the scale of the data that you have access to or that you're processing. So again, this comes back to asking that question about, do you know what data you hold? I dealt with a small company, 2 people, a few months ago now, and they were processing tens of thousands of children's information. So again, it was, you know, you need to have a data protection officer or have access to a data protection officer, because the amount of processing of large scales of special category of data is was excessive. It was clear. So if you're a dental practice or if you're in the health, I would suggest that you probably will need to look at DPO type responsibilities. So who are you going to connect to with that? So that would be a good example where a number of dental practices might come together to say, you know, we're going to by the services of this organization who will be our DPO, and they will advise us of any changes in the regulations, any incidents that we have, they will handle them, any subject access requests, they will handle those sorts of queries.
Okay, and a question around outsourcing the DPO. If you do outsource a DPO, will they be legally responsible in the event of you know, a breach or a failure?
Potentially, they, you know, again, this is part of a wider conversation on GDPR about understanding your third parties, and third parties are defined within Article 4 as well. So they could be, quite possibly, but that would be down to you to set that within your contracts. Certainly within the organisations that we're working with, we have, for instance, our professional indemnity insurance has gone up because we are saying to organisations, we will act as your DPO, and in the event of that we give you some professional advice which is wrong, then absolutely, you know, we will be held accountable. So yes is the very simple answer, but check your contracts if you are going to put that. Check your provider. Okay.
Another DPO question coming in there, and this relates to: would you need a data protection officer if you're, you know, if you're an organisation like a sports club, where in particular you might be dealing with juvenile teams, you know, again, kids teams?
Again, I would say that it depends on the kind of information that you're collecting. If you do not wish to have a data protection officer, you know, again, this is the GDPR is setting out very clear rules around what you should or should not do, but it is open enough for interpretation. So if you said, look, you know, I run a sports club, you know, it's you know, I've got 30 children or I've got 100 children on the records, I don't think I need a data protection officer. However, I'm going to note the fact that I haven't got a data protection officer, and the reasons I don't have a data protection officer are for these following reasons. It is literally about writing it down, going through that process of your decision-making process, and saying, you know, you understand it as a risk, and here are the mitigating controls around it. You're ultimately making yourself the data protection officer. You will be the person who will be ultimately accountable. You will be the person who will be understand the, or needing to learn about the technical security measures and risk mitigation methodologies, as well as the legal aspects as well. So you're kind of putting the onus on yourselves.
Okay, I'll take one more DPO question, and it's just in terms of the DPO, should they have any specific qualifications or requirements?
Again, it's a good question, and I kind of I touched on it there very briefly in terms of the GDPR, without trying to open it up and give you direct quotes here. It does make the position very clear that whoever the data protection officer is should have both a good understanding of data protection laws and EU laws, but that they should also have technical skills in terms of understanding information security and risk mitigation. So, you know, if you're just, with all due respect to lawyers and the legal profession, you know, it's unlikely they're going to understand about VPNs, you know, virtual private networks. It's going to be unusual for them to understand about what is appropriate technical controls to put in place. I dare I say it's easy to come from a technical background into a legal and understanding the data protection laws. So yeah, so no specific qualifications, but a good understanding of both data protection, the legal framework, and technical and operational security measures.
Okay, so a question around discovery, and are there any sort of tools that you would recommend, you know, for discovery in finding sort of the relevant data that you're holding?
I mean, there's various different tools. SIEM is just a very simple one, you know, in terms of understanding your SIEM, so understanding your data landscape, you know, just getting a printout of your folder structure, your file structure. So going back to your IT team and just simply asking them for, you know, that kind of information. There are a variety of different, quite expensive tools out there. I think initially, to be honest with you, I'm not a fan of throwing technology at a business problem. I initially would suggest the best tool is to have a workshop, get your heads of each department into your business, from your business into a room, and workshop this to understand what personal data they're holding and get them to come to you with that information. Because the only problem with trusting software to do that data discovery is that information quite often is held within CRMs and, you know, relationship management systems and such, and that's a bit of a problem. But there are various different tools out there, but I wouldn't recommend any at this point.
Okay. And again, it's around data discovery. Well, indirectly, they're saying, are you as a business responsible for the data that your staff may hold on their personal devices or their work devices that you might not have visibility of? So I think they're probably talking in terms of like where you've got salespeople who've got contacts maybe from previous roles and things like that.
That's a very good question. You as an organization, it's your role to make, if it's your device, if it's a company device, then you are responsible for that, and the protection of the information that's on there. If you're talking more BYOD, bring your own device, and it's information that people are holding on their personal devices and such, no, you're not. You can't be accountable for that, for what people have got in their own personal contact databases. But that's a question again to ask, and that's a good point back to the previous question, is asking people, do we store things on personal devices, or do we allow BYOD, bring your own device, and what kinds of information is held on those devices? How do we control it? And do we need to control it? So if you're not under control, then it may be a risk. Put that on the risk register. But you can't be held accountable in a practical way for information that is held on someone's own device. If their own LinkedIn contacts, that's not something that you can control.
Okay, this is one that's close to my heart. So under the right to be forgotten, if you're using an image-based backup system, it's not possible to delete specific data from an image-based backup without destroying the backup. So how do you then deal with that request?
Okay, that's a really good question, and yeah, I know it's quite close to your heart. This. What I would say is that GDPR is not meant to get in the way of doing business, and it's not meant to make things hard. I know a lot of people probably think it is, but it's not intended to do that. And I had this conversation with an organization just before Christmas, and they said, look, do we have to think about the backups as well if somebody asks for the right to be forgotten? And I just simply said this: normally, through your normal backup process, they will be erased anyway through the grandfather, father, son sort of cycle. So they will ultimately be forgotten anyway. If in the unlikely event that somebody in December asked for the right to be forgotten, and then at the end of December you had a catastrophic disaster and you had to restore all of your data, meaning that Gary is now back on your system, all you would do as your DPO, as the person responsible for data protection, would need to go back and say, well, if we recovered from the beginning of December, who have we erased since then? And you would just simply re-erase that person. So you would just reenact it. The GDPR itself states that you will, as far as possible, you will apply people's rights, or you will enact people's rights. So whether that be the right to be forgotten, or right for portability, or right to access, it essentially says you will do as much as you possibly can. But if you turn around and said, look, we've removed you from all our systems, but they are on a backup and that information will be destroyed within the next month, that is perfectly acceptable. So you don't have to worry too much about your backups. Okay.
And there's a question here around CCTV, and the question is, what are the main concerns in relation to CCTV footage, such as storage, footage access request, etc.?
There's a whole other regulation that is associated with CCTV, and I'm not an expert in that by any stretch of the imagination. All I would say is that if your CCTV can identify an individual, their image is as much as a part of GDPR as anything else. So in that sense, you will be, you need to think about it in much the same way as any other data. So you need to think about retention. So again, how long are we holding CCTV footage for? Why are we holding it? Who has access to it? And if someone was to ask for that information, that they can, under a subject access request, they can ask for that information, and what are the conditions for that. So that's really all you need to think about. Is a GDPR is relevant to all information, irrespective of its form, if it identifies a personal, a data subject.
Okay. So Gary, the next one is about reporting a breach, and under what circumstances do you have to report a breach?
Right. Okay. So a breach notification is really, in terms of the significance of this, is you may have to report a breach if there's going to be an impact upon the rights and freedoms of an individual. If the data is of a significant size, you would have to consider reporting a breach. But essentially, it's down to you to decide whether you want to actually make that call or not. And it is down to you. It is down to you to decide whether you want to inform the ICO. If you are going to inform the ICO, you have 72 hours in which to do so. It needs to be part of your incident management process where you ask those questions. So the questions being, is this likely to have an impact upon the rights and freedoms of the individual? Is the data of a significant nature that would potentially have an impact upon people? And is the data of a sensitive nature? So this is more, GDPR doesn't sort of set those rules in that respect. These are the kinds of things you need to ask yourself. You may not have to inform the ICO if the information has been anonymized, and that typically means encryption. So again, this is sometimes where the IT guys jump on and say that encryption is mandatory. That's not true. It just means that you may not need to inform the ICO. Okay.
All right. I think we've kind of come to the end of the questions, and we're also we're gone past the top of the hour. So just I think we should park it there, unless there's any just final shout out to anybody else who had a question. I don't think so. Okay. So I'm going to hand over to Noel and let him wrap it up, and then we can. Bear with me. Okay. Oh, right. I think I can see Noel's.
Yep.
Okay. All right. Noel.
Thank you, Janet.
All right.
Okay, lovely. Thank you, Janet, and thanks, Gary. That was a really good session. I think it's fair to say that's taken a lot of fear and uncertainty out of the whole subject. So thank you very much indeed. So really, this is just a thanks to everybody who's joined us today. Just to reiterate, as Janet said earlier on today, we will be making a recording of the webinar available to everybody who's been on here today. And of course, if there's any questions or any queries, you can come back to us directly, either here in Contact or any of the guys in StorageCraft. Be happy to help you as well. Before we finish up, just wanted to let you know that we do have another couple of webinars and events coming up in conjunction with StorageCraft over the course of the next month. So we can see there on the 26th of January, we have a StorageCraft versus ransomware, certainly another top topic at the moment, and how we can combat that using the one blocks, which I alluded to earlier, and the Shadow Protect SPX. Then we will also have on Dublin, February the 8th, StorageCraft will be represented at the MSP Trailblazers event in the Aviva Stadium. For anybody out there who is looking at the MSP route and is considering becoming an MSP, this is certainly an event that you should consider registering for. The reason being is that we will have guest speakers from very, very large MSPs who will be discussing their route to becoming an MSP, the problems they face, the challenges, and how they overcome them to become a dedicated MSP model. So again, in follow-up to today's webinar, we will send out registration details where you can link in and you can register for those events as well, and we hope we might be able to see you at that. So in that, just wanted to say thank you very much once again to everybody and to our speakers today, and really appreciate your time. Thank you very much indeed.
Thank you.
Bye-bye.
Bye-bye.